Continue is second to crop supplemental is second to 72 of 2025.
I was referring to from the part of the paragraphs. Two the four paragraphs. That is page number 2939. But first column 2939. This court then carried on following principles. As a much important. Second point. A document required to be registered if unregistered is not admissible into evidence under section 49 of the Registration Act. Such unregistered document can, however, be used as evidence for collateral purposes as provided in the proviso to section 49 of the Registration Act. A collateral transaction must be independent of or divisible from the transaction to the effect which the law required registration. A collateral transaction must be a transaction not itself required to be effected by a registered document, that is, a transaction creating, etc., any right, title, or interest in the immovable property of a value of 100 rupee and upwards. If a document is inadmissible in evidence for want of registration, none of its terms can be admitted in evidence, and to the use of document for the purpose of proving an important clause would not be using it for a collateral purpose. To the aforesaid principles, one more principle may be added, namely that document required to be registered if unregistered can be admitted in evidence as an evidence of a contract of super specific performance. Number 10, next column, last one. In so and so, this court has held that an unregistered document may be received as evidence of contract in a suit for specific performance. In the present case, the respondent number 1 has not instituted any suit for specific performance. Moreover, the power of attorney relied upon was unregistered and had already been revoked prior to the execution of the deed. Therefore, the respondent number 1 cannot rely on unregistered document to assert any proprietary rights and had no valid authority to execute the impugned sale deed. Additionally, Section 54 of the Transfer of Property Act 1882 categorically provides that a contract for sale of immovable property does not by itself create any interest or charge on such property. In the present case, the respondent has contended that the agreement to sell dated 24/5/2014 was instance a transaction executed as a security for loan amount received from respondent number 1 and was effectively in the nature of mortgage, and they are now ready and willing to pay the loan amount and deemed mortgage property. As already stated, the agreement to sell, power of attorney, and other connected documents relied upon by the respondent were unregistered and therefore in law cannot confer any title, interest, and ownership right in respect of the subject property. It is also significant to note that these documents were expressly revoked by the appellant on so and so prior to the execution of the sale deed. Moreover, the respondent number 1 has not filed any suit for specific performance of the alleged agreement to sell, which further renders his claim untenable. In the absence of suit for specific performance, the agreement to sell cannot be relied upon to claim ownership or to assert any transferable interest in the property. This legal proposition has conclusively laid down by this court in Subrajnath Industries, wherein it has been held that unregistered agreement to sell, even coupled with possession, do not convey title or create any interest in the property. It is further clarified that such documents are insufficient to complete a sale unless registered and followed by the private conveyance, appropriate conveyance. Paragraph number 10 is also important. Next column, last paragraph. Next column, last paragraph. In so and so reported in 2004 Art SCC, page number 1614. The protection under section 53A of the Act to the proposed transfer is a shield only against the transferor. It disentitles the transferor from disturbing the possession of the proposed transferee who is put in possession in pursuance to such agreement. It has nothing to do with the ownership of the proposed transferor who remains full owner of the property till it is legally conveyed by executing a registered sale deed in favor of transferor. Such a right to protect a possession against the proposed vendor cannot be pressed in service against third party. 18. It is thus clear that the transfer of immovable property by way of sale can only be only by a deed of conveyance, sale deed. In the absence of deed of conveyance, stamped and registered as required by law, no right title interest in the property can be transferred. 19. Any contract for sale which is not registered deed of conveyance would shortfall from the requirements section 54 and 55 of the Transfer of Property Act and will not confer any title or transfer any interest in one property except the limited right granted under section 53 of TP Act. According to the Transfer of Property Act, the agreement to sell, whether with possession or without possession, is not a conveyance. Section 54 of the Transfer of Property Act enacts that sale of real property can be made only by a registered instrument, and agreement to sell does not create interest or charge in subject matter. Whereby we are referring this what I say that this agreement to sell, whether possession has been delivered or possession has not been delivered, does not create any charge on the property. So far as the claim of prospective purchaser is concerned, this is something which is an abeyance, which is subject to the outcome of title suit. And unless and until the suit is decided, they cannot claim ownership because I am the owner and there is no concept of prospective purchaser. If the prospective purchaser culminates into a decree and deed is conveyed, then he can claim ownership. Now, on these lines also may not the following paragraphs further are there under lordship permit.
They are not claiming ownership.
Yes.
They are not claiming ownership.
They are claiming possession to basis section 53A.
They are given up that
yes.
key. You forget it.
Yes.
You forget 53A because they are given up that key. The law is well settled.
Yes.
That they cannot take the recourse to section 53.
But if they do not take, no, not kindly see MOU then. I will answer them again. I will not after seeing the exhibit A. But this is the exhibit A is the MOU.
Yes.
I would like to read the full text. Today, that is 3rd September 2007, at Ranchi, memorandum of before I start, kindly have the back side of this document. This is document has been procured on 19th of March 2007, and purpose is the affidavit as well as just this agreement is 3rd September 2007. At the Ranchi Memorandum of Understanding MOU between the Pawan Kumar Jaiswal and son of so and so. This property is located at Ashok Nagar. So and so. Here for the first party. Point number 1. The first party is in possession over plot number 393B as a tenant since 15 January 2001 of the legal allotted second party, owner second party, and regularly making payment of monthly rent at rupees 3,500 per month to the second party, and is willing to purchase the said plot with building and fixtures if the second party desires to sell the same. Second, the second party admits and accepts that the first party was given in possession as a tenant on 15 January 2001 and the monthly payment is being paid regularly. The second party has assured the first party earlier verbally that if the second party shall sell the said plot number so and so with building and fixtures, then the first party will be asked with a preference. Now the second party is in need of money for treatment and other requirement and decided to sell the land, said plot and building fixtures at the cost of rupees 35 lakhs only. The first party agreed to pay a value of rupees 35 lakhs only as an advance handed over an account paying check number so and so, Bank of Maharashtra, account number so and so, dated 8/10/2007, issued by the first party in favor of Ajit Kumar Sinha as per the directions of the first party. Not here important is date 8/10/2007. The check was issued. Fifth, the second party accepted the said check and directed the first party to make at least 10% of the total value of 35 lakhs rupees as advance. Then the document of agreement of sale shall be executed and further total amount must be given to the second party within 3 years from today. On these terms and conditions, this MOU shall be binding on the parties and its successor. If required, amount shall not be paid or the check accepted by the first party today shall not be encashed, then the first party shall be treated as a tenant and monthly rent of rupees 5,000 shall be recoverable from the first party after 15/10/2007 and this MOU shall be cancelled. Now, my lord, the agreement to sell was, this MOU was prepared on 3rd of September 2007. My lord, this check was issued on 8/10/2007. Now, my lord,
Check is dated 8. When we issued any date,
check issued.
post it,
Sorry, madam.
post dated check, है ना?
Not check ऐसा नहीं लिखा होगा ना. We cannot incorporate some word. But this issued check dated 8/10/2007 issued by the first party.
It means the same.
Now, my lord, kindly take my lord. ठीक है, issued अगर उसी चीज को प्लस समझते हैं. Kindly take my lord now. Exhibit C perhaps. Just a minute. Exhibit C. I assume that this check was issued on 3rd September. Can you see Exhibit C? Sorry.
And then
Yes. My lord, this is the first page of Bank of Maharashtra. Now, my lord, second page. My lord, the first date you lordship may see is 4th October 2007. The check was issued of 30,978. My lord, again another check was issued of 1,33,022 the same date. My lord, my check is on serial number 4, which they say, my lord, 1 lakh, which is marked Exhibit C. My lord, 4/10/2007 का डेट चल रहा है कंटिन्यूअसली. अब आता है नेक्स्ट डेट 5/10/2007. 5/10. My lord, अगर हम लोग समझते हैं कि 3rd सितंबर को अगर मेमोरेंडम बना था तो चेक इन बिटवीन कैसे इशू हो गया? As you have got my point, my lord, what I am saying. My lord, memorandum was prepared on 3rd September 2007.
you see, that is not the scope of question.
Yes, my lord. What I am saying.
We are not hearing a first appeal on this.
Yes.
Right? You have not filed any petition that any further substantial question.
Why
was
should I?
asked.
No, this is
You
not
can.
my opinion.
It is permissible in law.
Yes.
In a case, if there is any
Yes.
substantial question of law, even the
My lord,
respondent
why
can
I
file it
am
before us.
showing so, my lord? This document is disputed. When this document is disputed, this document is not required to be registered. This document is required to be registered if they claim, my lord, on the basis of this because rent has been Lord, the averment of the contempt, Lord, they are saying that on the basis of this document, there is an averment that landlord-tenant relationship cease.
This particular check is not carrying any date.
Yes.
So far as this date is concerned, it is blank.
Blank. Lord, serial number देखिए.
Serial number से आपको जरूरी है आप serial number से check issue करेंगे. Is it under आप अपनी check book के किसी भी लीफ को नहीं निकाल के दे सकते हैं क्या?
निकाल सकते हैं.
फिर
मिलट उसके बाद का डेट तो देखेंगे.
उसके बाद ये 4 का ये 2 डेट है इसमें ब्लैंक है. What do we draw out of this?
Lord, this was for the purpose of rent. Subsequently, this document has been procured and created this document for the purpose of this suit. After he filed a suit in the month of December, and they filed a written statement in the month of October, March 2007, my lord, 2010, 10, my lord. Then in the meantime, they procured this document. My simple case is this, my lord. And in the meantime, they have procured this document. And my lord, kindly see, my lord, and kindly see, my lord, the bank statement which is marked Exhibit B also.
You see, the check was issued in the year 2007. You adjust it against the dues of the year 2003-04.
जब पैसा मिलेगा तब तो एडजस्ट करेंगे. हमको
So,
पैसा मिला एडजस्ट
your husband never raised any grievance for non-payment of rent, although he died in 2009.
He gave legal notice.
His legal notice is not on record. From where you say he gave legal notice?
Perhaps he gave legal notice. Just
उनका legal notice दिखाइए कौन सा exhibit है? It is your legal notice which is on record. And there is no finding कि default कब से है.
Default
how do we read it?
Has been declared on the basis of personal necessity.
No, you forget about that. There is no finding कि default कब से है exactly. कुछ finding ही नहीं है.
Default कब से अब ठीक है मैडम जो है.
तो हम आपसे ये पूछ रहे हैं 2003 से आपने बोला कि पेमेंट नहीं किया. उसके बाद बोला कि 2004 दिसंबर तक हमने एडजस्ट कर लिया. ठीक है. Your husband never took any steps for realization of rent of the year 2003 till his death. Where is his legal notice? His legal notice. बताइए उनका लीगल नोटिस कौन सा है? उनका कोई लीगल नोटिस नहीं है. He slept over the matter. Simply, he never raised any grievance. 2007 में चेक मिला उसको 2003 के रेंट में आप एडजस्ट कर. Very well.
उस मेजर में म्यूचुअल अंडरस्टैंडिंग हमको रेंट मिला उसको एडजस्ट कर दिए. अब उसके मरने के बाद ये डॉक्यूमेंट क्रिएट हो रहा है. ये डॉक्यूमेंट क्रिएट जिसको हम डिस्प्यूट कर रहे हैं मेरट का जो भी
Maybe I'll tell you one thing. One law is very clear. These are all summary proceedings, right? इसमें कुछ भी फाइंडिंग जो भी यहाँ रिकॉर्ड होगा या होता है in connection with agreement has got no bearing in your title suit which is pending. There is no doubt on that.
Yes,
if you are disputing this document in the title suit, that will be taken care of in the title suit. Right? The law is well settled.
Yes.
There is no finding of the courts that this particular document is forged and fabricated. No finding has been recorded. And the court has simply thrown away this document by saying that it is unregistered. The court has also not examined as to whether this document can be relied upon for collateral purpose. Right? वो भी नहीं किया. Collateral purpose क्या होता है इसमें? One of the collateral purpose would be whether there is an agreement not to pay the rent for some time. That would have been a collateral purpose. When two persons, landlord and tenant, they agree that okay, we enter into an agreement for sale, and you do not pay the rent, and if ultimately the the sale deed is not executed on behalf of other, there is a default clause कि अगर लैंडलॉर्ड नहीं करते हैं एग्जीक्यूट तो वो रिटर्न करेंगे पैसा with 18% interest, और अगर टेनेंट नहीं करते हैं then he will pay the rent with whatever at the rate of 10,000 per month, right? 3,500 रुपए का टेनेंसी उसमें दिख रहा है, ठीक है? कोई भी एग्रीमेंट पहले का नहीं है, एक भी रेंट रिसीट नहीं है पहले का, ठीक है? तो क्वांटम ऑफ रेंट इज एब्सोल्युटली फ्लूइड. उसमें 10,000 रुपीस का रेंट फ्रॉम अक्टूबर 2007 पेमेंट करने का क्लॉज है, और बिफोर दैट पर्टिकुलर कट ऑफ डेट अराइव्ड टू एग्जीक्यूट द सेल डीड, द हस्बैंड एक्सपायर्ड. Now you completely back up. Now you tell me whether these two clauses would constitute collateral, even if your every argument is accepted. Will these two clauses constitute collateral purpose or not? And whether the learned court has completely ignored even this aspect of the matter, that these agreements were required to be considered only for the, at least for the purposes of collateral purpose.
Not so far as jural relation is concerned. Lordship is talking about only jural relation. The jural relation will come into play only when there is we accept the agreement. We are not accepting the agreement. Lordship judgment was there of the 80 of 2018 Milord. That judgment where there is an agreement Milord was accepted by the parties. Parties flow from there was agreement.
You say there is no finding. How do we in second appeal give a finding that this particular document is forged and fabricated?
Therefore, Milord, Justice Iqbal's judgment is there in the eviction suit. We cannot see the agreement to sell.
Much water has flown thereafter.
Yes, ma'am.
Much water has flown thereafter. Thereafter, the subsequent judgments have taken note of these, but all these subsequent judgments. But in all the cases, that there is a distinguishable feature.
Well, in the 2000 judgment on which Lordship is relying upon, that is also distinguishable.
I am not relying upon
it. I'm sorry. The appellant is relying.
I am not relying upon it. Why should I rely upon?
I'm sorry.
It is for you to rely upon.
I take back my words. The appellant is relying upon that 2000 judgment. That again, my lord, there are two scores, my lord. That first, my lord, that there was an agreement between the parties which was accepted by both the parties. Here, my lord, I do not accept that agreement.
That is a separate thing.
When we do not accept this agreement, why, my lord, the conditions mentioned here is required to be fulfilled. The possession has been seized.
But that is not the reason assigned by the court. That this agreement is forged and fabricated and therefore it cannot be relied upon. The only reason assigned by the court is that this document is unregistered and therefore I will not rely upon this.
My lord, where is the pleading, my lord? There is no pleading in the WS because of this it does not require registration. In the pleading,
there are two parts. One is 53A rejected, no problem. The second part is that as per the agreement, he was not supposed to pay rent, and he has referred to the clause of the agreement. The clause of the agreement are twofold. One is that he is not supposed to pay rent, and other is in case the agreement does not translate into a sale deed, the consequences have also been mentioned there. Therefore, you just think of a situation, a landlord and a tenant, right? They can agree, there is an agreement of tenancy. It is not necessary that it has to be registered, right? Because it is month-to-month tenancy. Registration is not required. And in this case, admittedly, there is an oral tenancy because there is no agreement of sale. Initial tenancy is oral. Now, this particular agreement comes into picture, wherein the parties agree that yes, this particular rent is not payable because we are entering into an agreement of sale, and if this ultimately does not fructify into a sale deed, then this is the consequence. Then, if the party they themselves agree that the payment of rent is deferred till that date.
Parties agree, my lord. Here I come, my lord. Parties do not agree, my lord.
That's right. Because the agreement is forged.
Yes.
So did you take any steps for examination by handwriting examination?
Why should I, my lord? It is their case. If the document would have been registered, then definitely local onus was upon me. The document is not registered, onus was upon them.
There is no finding of the learned court that it is a forged and fabricated document.
And
in the second appeal, I will not give any such.
No, my lord, your lordship is giving a proposition, my lord, that since your lordship has formulated a question, that
the
agreement.
Question is that whether this agreement could have been thrown merely because it is an unregistered.
Yes, therefore, my lord, I am answering this.
So therefore, the court has not taken into consideration whether it can be relied upon for collateral purpose also, because this provision is so clear that if even if the agreement of sale is unregistered, then also it can be relied upon for collateral purpose. The court simply throws the document by saying that it is unregistered, I will not look into it. Is it proper?
But since the document was disputed, why should the Lord, just I'm not further member. Lord, one thing more I would like to place member that Exhibit D may kindly be seen. Once again.
Exhibit D.
Yes. Lord, first of all, Exhibit A, and thereafter Exhibit D. Lord, this agreement is of 3rd September, which says, my lord, that on 8th of 7th, the same check was encashed. It was issued. On 8/10/2007, it was issued. On same day, it was encashed also. Lordship is saying it was a post-dated check and subsequently.
No, I am not saying.
Yes.
The check carried a date.
Yes.
The check carried a date.
In the word, in the MOU, it is mentioned the check was issued on 8/10/2007. And the same day the check was encashed. It is not mentioned that a post-dated check was given. On the same date check is encashed. How is it possible? Nowadays, it is possible. Now in 2007, it was not possible. On the same day, the check is given and check is encashed. This is my humble submission. Therefore, my lord, this document is a created document. Now, my lord, kindly see the agreement to sell also again. Exhibit E. The signature, my lord, quote is experts of all experts. Lordship may just kindly see the signature. Satyendra Kumar Sinha. Will not kindly see the Kumar here and all the pages. K, word K.
I am not here to compare.
But I am just informing my lord that I dispute this document.
You dispute this document, it's well that you are disputing this document, but there is no such substantial question of law that even otherwise, even if these documents are considered, then also this particular document is forged and fabricated and cannot be relied upon. There is no such substantial question of law.
No finding also.
My lord, may kindly take now this 2022-13 SSC.
2013
SSC.
Just
Mohammed Raza versus Geeta. You would like to place some facts also for this one.
yes. 2013.
Yes. 2022 volume 13 SSC.
Yes, and then
Para number 2, the short facts number 2.1. The respondent original plaintiff had instituted civil suit number so and so against original defendant appellant herein in the court of civil judge so and so for possession, mandatory injunction, permanent injunction, and messenger profit with respect to the property of so and so. It was averted in the plaintiff that she is a lawful owner of the property since 15/1/2013. Defendant number 1 is the tenant, white, rent agreement dated 14/3/2016, who is legally sublet the property to defendant number 2 without any prior intimation to the plaintiff, and thus the tenancy of the defendant number 1 has been terminated by the plaintiff on 17/7/2018. Thus, the plaintiff claimed ownership and claimed the original defendant number 1 as a tenant. At this stage, it is required to be noted that defendants filed the written statement.
I just want to know that on what proposition are you relying?
Lord, this is on the second substantial question of the law. At this stage, it is required to be noted that defendant filed written statement. After the written statement filed on behalf of defendant, the plaintiff filed an application before the learned trial court to pass a decree on admission under Order 12 Rule 6 on the ground that in the written statement the defendant have admitted that the plaintiff is the owner and defendant number 1 is the tenant in the property. But here also they have admitted that directly relationship. The said application was opposed by the defendant as
It was an application under Order 12.6?
Yes. A detailed reply was filed under Order 12 Rule 6 on behalf of the defendant. Thereafter, the trial court dismisses the application by order dated so and so by observing that the producer of the written statement filed by the defendant, it is palpably clear that defendant number 2 did not make any admission regarding the ownership of the plaintiff and the tenancy of the suit property. Feeling agreed with dissatisfied with the order dated so and so, not be preferred High Court देते हैं. High Court में यहाँ पर decree of eviction was set aside. The revision कहते हैं. At this stage, the paragraph number 4 and at this stage, it is required to be noted that the written statement, it was a specific case of the defendant, the appellant herein, that defendant is the absolute owner of the suit property and has paid a sum of 19 lakhs to the plaintiff, and therefore she is in possession of the suit property as an owner. However, it is noted that defendant number 2 had instituted a suit against plaintiff for specific performance of contract, on the basis of which defendant number 2 is claiming to be the owner of the suit property, and said suit is still pending in my case also. So that's point number 7.1. Same page, last paragraph. It is submitted that in the case of on behalf of defendant, more particularly defendant number 2, that she is the owner of the suit property, therefore she is in possession of the suit property as an owner. It is submitted that defendant number 2 is claiming to be the ownership on the basis of an agreement to sell. It is submitted that the agreement to sell does not confer ownership at all. A person in whose favor agreement to sell is executed becomes an owner either pursuant to the deed executed by the executor or a decree or a specific performance of the contract has been passed. It is submitted that even as per the case of defendant number 2, a suit for specific performance is pending. 7.2. It is submitted that if the written statement is wholly considered, in that case there is an admission on the part of the defendant that the plaintiff is the owner, and even the tenancy in favor of defendant number 1 also has been admitted. However, in the case on behalf of defendant number 2, she is the owner, and as an owner she is in possession of the property as no legal basis. Now we got para number 11 and the last. Yes. Para number 11. Now this is the finding. Thus, from the aforesaid, it is clear that defendants are claiming ownership of the suit property. Defendant number 2 is claiming to be in possession as an owner and claiming to be the owner and claiming to be the owner. It is to be seen that the plaintiff has filed a suit as an owner. It is not in dispute that even it is a case of the defendant that defendant number 2 had instituted a suit for specific performance against plaintiff with respect to the suit property, meaning thereby there is a clear-cut admission that the plaintiff is the owner. It is to be noted at this stage that defendant number 2 cannot be said to be the owner as her suit for specific performance is yet to be decided by the learned trial court, unless and until there is a decree passed in favor and the decree of specific performance is passed and the sale deed is executed pursuant to such decree. She cannot be said to be the owner of the suit property. till the suit for specific performance is decreed. The plaintiff respondent herein continues to be the owner and defendant appellant herein continues to be the tenant. In the written statement, para number 1, it is specifically stated by the defendant that defendants are not now tenant of the plaintiff but the actual owner of the property. It is observed herein till the suit for specific performance is decreed in favor of the defendant, more particularly defendant number 2, she cannot be said to be the owner and therefore the plaintiff respondent herein continues to be the owner and defendant continues to be the tenant. Therefore, the aforesaid is the rightly treated to be as an admission on the part on behalf of defendant with respect to the ownership of the plaintiff and that the defendant number 1 is a tenant. Therefore, the High Court as such has rightly passed a decree or admission under Order 12.6, which is the facts and circumstances of the case not in place. But here in my case, it is exactly the same. The
They are
suit is
not
pending.
claiming ownership.
You're
They are given at the plea of claiming ownership. Am I correct? Yes, appellant, you have given at the plea of claiming ownership?
हम तो
They are not
बोल ही नहीं
claiming
रहे
ownership.
हम ownership
Not
कहाँ
at
से
all. And if they claim that plea
So
will be
what
outright
is
rejected.
what is their status, my lord? I put a question to myself. What is their I am a owner. My lord, they sued for specific performance spending. Then what is their status and what is my status? And what capacity they are residing in the property? They are merely, my lordship is admitting that lordship, my senior colleague is admitting, my lord, they are not claiming ownership on the basis of the agreement to sell. Under what capacity they are there? Illegal possession then?
They are not in illegal possession.
My lord, on what capacity? I put a question to myself.
Had you filed a suit for eviction on a general title suit for eviction, right? On the basis of your title and claiming possession, right? That situation is different. But it is a case you are filing a suit claiming landlord-tenant relationship, and they are claiming that their status as their status is that of a prospective owner, a prospective purchaser of the property. They are not claiming title so far. They are not claiming title so far.
They are prospective.
And they are further claiming that by virtue of the agreement there is an altered position that the rent is not paid.
But the prospective purchaser, that's why prospective purchaser is concerned. Where is the concept of prospective purchaser? To be prospective purchaser after since only on the basis of a one thin line there is an agreement which is spent sub judice before the
Merely
court.
because there is an agreement, they might not have any claim at all. But with those clauses staring at us, where there is an agreement to defer payment of rent, with further clauses that if it does not come into existence, if there is no sale deed executed by October or whatever in the month of 2010, then there will be a refund of the amount and there will be adjustment of the amount and he will be liable to pay right from October 2007. Those clauses are also staring at the agreement. That you have said that is forged.
Yes, there is a difference, in this judgment which I relied, the agreement was admitted. Now, all the judgments which have been relied by either my friend or I would
see,
be
there are two things. And kindly address on two portions.
Yes.
One is that when there is an admitted agreement, let us assume a situation that this agreement stands admitted. Then what will be your argument so far as these two clauses are concerned?
Well, if the agreement are admitted, my lord, I will board out to my lordship's view. That is the Supreme Court judgment also in this point, my lord. If the agreements are admitted, now here, my lord, in this case, lordship has also passed a judgment and that line also only, my lord. When the government's agreement, in the agreement there is a clause mentioned, agreed by both the parties, then, my lord, it is binding and it is binding, my lord. Now here I dispute, in every case, my lord, every eviction suit, when agreement will come into play, my lord, and the entire dispute or relationship will come into play, my lord. The one for document is come into picture, my lord. The entire dispute
But at the same time, there is no finding that this agreement
I
is
admit, my
forged,
lord.
and there is no substantial question of
Therefore-
law whether this agreement is otherwise also forged.
Therefore, my lord, I say, my lord, this agreement, my lord, that document, my lord, Justice Iqbal, therefore has said, my lord, in eviction suit, title cannot be seen. Justice Marathi also followed that view, my lord. And my lord, in coming further also.
No, we are not seeing the title in the eviction suit. We are looking at the agreement.
Yes.
And we are not looking at the title at all because
Yes.
title has not passed. Admittedly, it has not passed. They are not the owners of the property.
If lordship permit.
I'm looking at those clauses in the agreement. I'm looking at those clauses in the agreement which says that no rent is to be paid, and if the sale deed is not executed by 2010, then the parties will adjust their accounts in the
Yes.
manner which is provided there.
If suppose my lord, in every rent case, my lord, this eviction suit, this agreement, false document is comes into play, my lord, then eviction suit is not maintainable.
And at the same time, there is also a law that in case of complicated cases of title and these kind of forgery, etc., this eviction suit is not maintained.
My lord, I put a question to myself, my lord, in that
Because these are just summary proceedings.
If lordship holds this, my lord, then my lord, in every eviction suit, one false document will come into picture, my lord, and the suit will be dismissed.
Then the court will decide whether this document is forged or fabricated
then,
or
my lord,
not.
it will give the impact in the another suit also, my lord.
You see, I have also held in one case that any finding in eviction suit will have no bearing in title suit. If there is a title suit pending, it will have no bearing because this particular document, whatever the agreement of sale is, the court has to come to a finding only prima facie with regard in order to these, whether this document is forged and fabricated or not, etc. These are only incidental issues which, in order to come to the finding, whether there is the two things which the court has to see in BBC Act. One is whether there is a relationship of landlord and tenant between the parties, right? And secondly, whether there is a default in payment of rent. Even if it is assumed and it is correct that there is a relationship of landlord and tenant, then also the default has to be seen. We cannot ignore this default. Unless there is a default.
Well, I got it.
Yes.
I got your point, my lord. But I am stick on my point, my lord. I am trying to convince my lord that point, my lord, so far as the payment is concerned, that is subject matter of the specific performance.
Certainly, that is subject matter of specific performance.
But any finding in this, my lord, this will eventually impact, my lord, my suit or that suit also or their suit
It will
also.
not impact because I will not give any finding. Because that is not within the domain of my substantial question
Yes.
of law. I will not give any finding to that effect. I will record your submission, but I will not give any finding. It is beyond my substantial question.
My lord, my status will not be changed, my lord. I am not a landlord. My lord, they claim that I am not a landlord, and they are contesting to get a title on the basis of this agreement to sell. My lord, what is my status now? Who am I? Who has to receive the rent in the meantime, my lord, since 2007 to 2026? They are enjoying the property. I am outside. I am 91 years old lady, my lord. And my suit has been declared only on basis of personal necessity. I want to stay in Ranchi, and this is my husband has purchased this property.
No, those things are there. Those
Yes.
sentiments are very much there.
No. It is
But
not
the
a
point
sentiment,
is-
my lord. But my lord, my only case is, my lord, that every now and then, my lord, this one agreement will come into play, my lord, and this entire suit will be, my lord, thrown out, my lord, the eviction suit is not maintainable. My lord, can you take my lord next journey, my lord? Somnath case.
आपको थोड़ा हेल्प कर. If we read these two clauses together, that the payment of rent is not to be made, and if the agreement does not come into force, then they will adjust rent or there is a clause for refund. Let's take it for a moment. Then the parties do not agree to permanently to change their status permanently as landlord tenant, because there is still a clause that in case the agreement does not fructify into a sale, then the status of landlord tenant relationship will revive and he would be entitled to payment of rent. Right? So under such circumstances, he may not be a defaulter, but there is also a finding of bona fide necessity, and therefore the suit should be decreed on the point of bona fide necessity.
Yes.
Yes, आप कहाँ बहस किए? आप तो बहस नहीं किए. नहीं किया ना?
I was coming that the suit of personal necessity, and therefore the trial court has declared the suit of personal necessity irrespective of the default. They have not whispered. I admit, the trial court has not whispered uttered a single word with respect to the default.
ये डिफॉल्ट का तो किया है, मतलब डिफॉल्ट का फाइंडिंग यही है कि 2007 से एडमिटेडली आपने इन्होंने रेंट नहीं दिया, दैट इज देयर एडमिटेड सिचुएशन दैट दे हैव नॉट पेड।
डिफॉल्ट का पेंडिंग
इनका तो एडमिशन है कि 2007 से पेमेंट नहीं किया है, इनका तो एडमिशन है बाय वर्च्यू ऑफ द एग्रीमेंट दे हैव नॉट पेड। यस मिस्टर राहुल गुप्ता, इतना बताइए, उसके बाद इनको और बताइए। अगर मान लीजिए ये दोनों क्लॉजेस को हम लोग देखते हैं कि ये जो 2007 से आप रेंट पेमेंट नहीं करेंगे, but if it ultimately does not culminate into a say deed, then you will adjust your finances. And how will you adjust your finances? Either there will be a refund of the amount, okay, and then he will be liable to pay the rent right from September 2007. So do you intend to permanently end the relationship of landlord and tenant by
Yes, because I have already filed a suit for specific purpose.
That's right.
First. Second, your lordship used the term revival. Now, one thing is for sure, taking into account the term of the agreement, that at least landlord-tenant relationship has now changed from purchaser.
No, you see, it will all depend upon the terms and conditions of the agreement.
Yes, but they have not filed a suit. If their suit would have been that there was an agreement which contained this clause, and in terms of that clause, other clause was that if the parties do not perform, then I did not perform or he did not perform. Now there is a revival of the agreement between us.
That they have not said, because
it is not an agreement. So
they have not relied upon those documents because of the fact that they themselves said that it is supposed to whatever be there, that
no
is not the
finding at all.
No finding at all.
If there
fair enough,
have
no
been
finding.
then matter
You
of
just
that.
tell us whether the relationship of landlord-tenant between the parties exists or it does not exist. Will it depend upon the terms and conditions of the agreement or not? It will.
It will.
It will. So, in a case where there is a terms and conditions of the agreement that this rent will not be paid, and ultimately if the sale deed is not executed by a particular date, then the rent would become paid. What does the party intend? वही है, आप देखिए, जो बोल रहे हैं वही है। पढ़िए, आप एग्रीमेंट पढ़िए। Exhibit E पर एग्रीमेंट।
हाँ, मेरा इतना ही बोलना
Clause
है।
6.
हाँ, मेरा इतना ही submission है that pursuant to this, the rights of the parties would be dependent on the terms of the agreement. Now he cannot. I'll come to that. Now he cannot take shelter of the clause of the agreement also and deny the agreement.
See, we are on the point of law.
Yes.
That this particular agreement has been thrown out by saying that it is unregistered. Right? And if this is decided in your favor that this could not have been completely thrown out in the manner it has been done, then under such circumstances the consequences of the clause of this agreement has to be seen. Right? We will see that.
Yes.
Let us see this.
Yes.
That what is the consequence of clause number 6?
Yes.
Read it, please.
Yes, I'll read it. If the first party declines to sell, he will return the accepted amount with 18% per annum to the second party. And if the second party declines to purchase the property, then he has to pay monthly rent at the rate of 10,000 per month to the first party from October 2007 till the date of vacation of the building in question.
So
now this is to include. Now second part first, because that is the clause of tenancy. Now second part says that if the second party declines, so if I decline, then only the tenancy would be there.
That's right. But the point is
Yes.
that does this agreement and the clauses when read together does it permanently snap the relationship of landlord and tenant? Because if any of these events happen, the tenancy revives as per the agreement.
Revives, but happening on the event which has been
Certainly,
mentioned in the.
certainly. Therefore,
Yes.
whether the tenancy would survive or the tenancy would not survive will depend upon these clauses.
Absolutely.
So, therefore, there is no intention between the parties that the relationship is completely changed.
No.
And your status becomes that of a prospective purchaser only.
Because Your Lordship, it mentions that it would.
Think of a situation that this agreement does not fructify. Right? No suit for specific performance is also fine. Right? Then, under such circumstances, can he still file a suit for eviction on the ground of default in payment of rent?
Whether they can file out.
Yes.
But they'll have to play, then they'll have to make out a case in terms of clause 6. I'll come to that. I'm answering Your Lordship. Because rate of rent has to be there.
Those things are there. The point is,
Yes.
the fine point is whether this agreement terminates the status of landlord-tenant.
Yes, it does. It does. And it only says that in terms of clause 6, that if I fail to decline to purchase, then I'll pay rupees 10,000. Now, here the term or original rate was 3,500, which the same agreement mentioned that the original rate was 3,500. Their case is 15,000. So this particular 10,000 is absolutely a fresh clause that if we fail to, if I decline to purchase, then this is a fresh clause.
Before this agreement could be taken to a logical end by arriving at the cut-off date of 2010, the executor of this document expired.
Yes. And therefore, they were bound to this. The plaintiff stepped into the shoes of the original owner. Then she was bound to perform whatever was there in the agreement. And therefore, if it clearly mentioned that there is a severance of landlord-tenant relationship, then obviously all the consequences would. And
You
close.
just tell us that there is no suit for specific performance of contract. No suit, right?
Yes.
By virtue of this agreement,
Yes.
then you see that the relationship of landlord-tenant has.
No, it has ended. Then they have to file a suit that in terms of the clause of this agreement, the clause stipulated that if I decline, and by not filing, by the original owner dying, I am not filing a suit for specific performance. I have declined. So if I have declined, then I become a tenant and I am liable to pay rent at the rate
You
of
see,
10%.
the liability to pay rent is deferred, but the relationship does not come to an end. In my view, these two clauses take into this. And there is a decree for eviction on account of personal necessity. So that decree comes.
According to me, it is.
But defaulter, of course, you cannot be a defaulter. You cannot be said to be a defaulter because the parties agree that there is a deference in payment of rent. So there is no question of intentional default because they agreed as per your case, right? Even if this agreement is taken into consideration, the relationship does not terminate for all times to come. The relationship does not terminate.
But it says it is
says-
there in a particular condition. That condition is that if I decline, so I have
That's
not
right.
declined.
That's right. You have declined, they have not declined. These are all subject matter of the specific performance.
Yes.
But the point is that on the face of these two clauses, even if this agreement does not, the intention of the party is not to permanently terminate the relationship of landlord and tenant and give you a permanent status of a prospective purchaser. That is not the intention of this agreement.
But it says, Your Lordship, that particular clause would be there only if I
Our
decline.
market.
ठीक है. Only if I decline. If I have not declined, that that
वो तो बात की बात है
status
ना।
never
You
revised.
see, this document has not been taken into consideration.
No.
We are seeing this document from an angle whether it can be taken into consideration for even for a collateral purposes, whether the parties with qua their landlord-tenant relationship agreed for a deferred payment or any altered position, at least that would constitute a collateral purpose,
Yes, yes.
if not the main agreement.
Yes,
Right?
yes.
Then when we see these clauses of from the angle of collateral purposes also, then also this particular agreement does not intend that there is a permanent termination of relationship of
Separability of the landlord-tenant relationship.
permanent cloud जरूर है, eclipse जरूर है, लेकिन there is no such intention that the landlord-tenant relationship is permanently severed, and you acquire the status of a prospective purchaser for all times to come, and the only remedy for them to file a title suit seeking recovery of possession.
According to me, my
इतना हमको
submission.
पूरा दिन लग गया यहाँ तक पहुँचने।
हाँ ठीक है हम उसमें ये नहीं कर रहे, मेरा एक ही सबमिशन होगा, because of the clause which is there in third page, that clause severed, and the conditional, the clause 6 which the lordship is reading, that would come into play only in case where I
Certainly,
decline.
but there is no intention to permanently terminate the relationship of landlord and tenant. You see, the relationship of landlord and tenant would terminate for all times to come only if there is such intention, and then only we can give a finding that there is no relationship. But there is no, then under such, in view of these clauses, you cannot be held to be a defaulter. There is no doubt on that. But at least, so far as the personal necessity is concerned, there is no substantial question of law on that.
With regard to that, I cannot argue, because once my landlord-tenant relationship is there, then
You see, landlord-tenant relationship on the basis of these clauses, it does exist. There is some clout, some deference, some more arrangement between the parties. But there is no intention to permanently terminate the landlord-tenant relationship, because it says that in case it does not work out, that rent at this rate is to be paid. If the rent is to be paid, under what provision of law the rent will be paid?
If only if I decline.
That's
So
right.
then-
It's a
then-
conditional.
Then
So
actually
therefore,
Yes.
you cannot be held liable for default in payment of rent. The consequence of this agreement is that you will not be held liable for default in payment of rent. But personal necessity
But
is stated.
for the same period, how can I be treated as a tenant as well as prospective purchaser? Because the same agreement says that now I am not required to pay rent, because there is acknowledging that advance amount you have paid and further amount you have paid. So there is a concluded contract between the parties. So once that was there, then clause 6 would have come into play only if I would have.
Before that date, he expired.
But he
Before that cut-off date, he expired.
Therefore, the first clause does not, the first part is not there. The first party declines to sell, that would not be there, because he did not decline, he died. And the second part would be, then if I decline, I have never declined. So if I have never declined, then there is no question of that clause being put against me. The same clause which is, if I decline, would come into play if I decline only. Then only it would come into play. I have not declined because I have already filed a suit first. So if I have already filed, and in 2009 itself, I have filed, and then how this would be treated to be a tenant? I would be treated to be a tenant if I would have been declined. Then only.
इतना layered है ना ये civil law.
हाँ, एक बार खाली वही वाला 2000 वाला.
कौन सा 2000 वाला?
ग्रंथि माथि ग्रंथि माती 2009।
आप जरा देखिए ये वाला क्लॉज देखिए,
कौन सा? अच्छा,
जो क्लॉज उसमें था,
इसी में।
इसी में कंथी माती।
अच्छा, नहीं ये नहीं। It is there in para 4.
You read para 5.
ठीक है. As aforesaid, the question of consideration is whether the status of land tenant as such changes on execution of an agreement of sale with the landlord. It is relevant at this juncture first to examine the terms of the agreement for sale. The relevant portion of the agreement of sale record following: I, the aforesaid Mr. So and so, hereby agree out to you on my own free will to sell and transfer the property to you on so and so, and mutually agreed sale concession of 25,000. I shall be proceeding to Coimbatore and execute the sale deed and present the same for admission and registration before the registering authority, accepting the and acknowledge the payment of the balance concession of rupees 5,000 at the time of registration, and shall complete the transaction of sale of conveyance as the property demised has already been surrendered to your court.
So, I shall complete the sale as the property demise has already been surrendered to your possession. आगे
So,
बढ़ो.
submission for the tenant is after entering into agreement, the landlady accepted rupees 20,000 confirming delivery of possession in this context, which already constitutes the clear intent of the landlady of entering into new relationship with the tenant under it. On the other hand, learned counsel for the respondent submits that the words already been surrendered therein only refer to existing possession of the tenant and nothing more. So far as this submission for respondent is concerned, we have no hesitation to reject the same. The reference of the words already been surrendered has been incorporated with consciousness. This is to be construed in the background of the landlady having received a major amount of sale consideration, as normally if substantial sum is received by the seller, the purchaser is put in possession of the property, hence to fall in the same line the word used to confirm this possession in the context. There would be no other reason to record therein as such. Even if it is said to refer to possession as a tenant, the reassertion in the agreement of sale is only for the purpose of denoting possession given in pursuance of the agreement of sale. Any dual relationship between two persons would be created through agreement, and similarly could be changed through an agreement subject to the limitations under the law. Earlier, when the appellants were inducted into tenancy, it only means both agreed that their relationship was to be that of a tenancy, was to be that of landlord and tenant. Later, when the landlord decided to sell this property to the tenant, and the tenant agreed by entering into agreement, they by their positive act change their relationship as purchaser and seller. When the seller accepts the sum, he actually acts under this agreement. This acceptance preceded by agreement of sale changes their relationship. This is how they intended. Once accepting such a change, their relationship of landlord and tenant ceases. This quote in so and so, I'll read this also.
Yes, this is important.
This quote in so and so held as follows: the appellants were tenants in the premises of the respondent landlord, and 3 suits, including the eviction suit, were pending against them. By an agreement between the appellants and the respondent agreed to sell the whole property to the appellants for a certain sum to be paid to him or by equal installment. Clause 5 of the agreement provided that in case of default by any installment, the agreement for sale would stand cancelled, and if the purchaser failed to pay the defaulted installment within 1 month's notice, the payment made would be forfeited and the purchaser would make over possession over the property to the vendor. Such clause 5 under the agreement of the question of giving notice arises only if the vendor wanted to forfeit the installment paid by the purchaser. Not even one installment having been paid, the question of forfeiture does not arise and no notice was necessary for cancelling the agreement. It stood automatically cancelled. It was sought to be argued before us that once the agreement stood cancelled and the appellant stood restored to their position as tenant, and the suit would, would not be filed without notice under Transfer of Property Act. We are of the opinion that when the agreement dated so and so was entered into, the old relationship of landlord and tenant came to an end. The rights and liabilities of the parties have to be worked out on that basis in the agreement. Yes, I'll read out further. This decision clearly spells out that once there is an agreement of sale between a landlord and a tenant, the old relationship as such comes to an end. It goes on record that even after the cancellation of such agreement of sale, the status of tenant is not restored as such. In other words, on the date of execution of the aforesaid agreement of sale, their status as that of a landlord and tenant changed into a new status of that purchaser and the seller.
That's right.
So-
there was a clear clause that if the if amount is paid, then also it will be forfeited, and then he will be entitled to straightaway take possession of the property. Right? There is no such clause.
Now, here our
Here the
clause,
clause is
Yes.
different. Here the clause is different.
absolutely different.
Very, very
So,
different.
absolutely different. So, here is a clause which would fall into consideration only on my action. That if I do not do, but I have already done it, then even if I would not have done it, then only what would have been done, that fresh tenancy of 10,000 rupees would have been there. It would have been fresh tenancy. There was no question of revival of our old tenancy. This would have been, at best, on my denial, there would have been fresh tenancy. I've
It's
never
not a fresh
denied.
tenancy. It is a fresh tenancy with a fresh. It is not a fresh tenancy. It is a continuation of tenancy from the date you have been asked not to make payment, but at a different rate of rent, from 3,500
But that
to
would,
10,000.
yes, therefore, that clause which is on my default, that cannot be used against me for saying that I am still a tenant. Because that says that if I decline, I have never declined. So there is no question of treating me as a tenant relying on the same clause.
So
What it
you
says,
see,
I'll read it out one second. What it says, if the first party declines to sell, this is not your lordship is relying on the second party. Then declines to sell, he will return the accepted amount to so and if the second party declines to purchase, then he has to pay monthly. So I have never declined to pay. So I'm still a prospective purchaser. I cannot, that tenancy has never revived, and even if it is treated as the same tenancy, it has never revived. In fact, I am the prospective purchaser who has already, against the terms of I have already filed a suit for it. So there is no decline on my part. So this clause would not come into play as against me itself. And this time itself, if in subsistence of this clause, if I have not declined, then I cannot be treated as a tenant. That would come into play only on my declining to be not performing my part. And that therefore there was no revival of the tenants.
Just to add one thing. If that
no,
was-
you see, don't assume anything.
one more.
Don't assume anything. These observations are being made
Yes.
to ensure that we arrive at the right picture and we arrive at the right solution to the
Just
case.
one thing.
So we hear the case from all angles.
Yes.
From all angles,
Yes.
whatever possible. Even if we do not argue, we will suggest you some arguments like There is no problem on that because it's a substantial question of law which is to be decided.
One
It
thing
may
is-
impact many other cases also, so we have to be very careful. So you just don't assume anything. You can, whatever you want to argue, you can just.
But one thing just to add.
Since it was a question, so I just.
Well, one thing, Lord, if Lord, the second clause, the second party declines to purchase the property, then he has to pay monthly rent. In that situation, he could have deposited the amount in the court below when the eviction suit was pending to show his bona fide, which has admittedly not been done.
You had also not asked for 8 years of rent.
I have not asked for.
That is not.
The only my suit has been decreed basically, but there is no finding on default, but the suit has been decreed only on the basis of personal necessity. And since